Okay, it is March 12th, and we are going back to S87. And we have Attorney O'Hara here with us from the Defender General's office. Feel free to join us. Yesterday, we got a lot of input from the prosecution side of things, and just want to get the defender side, the defender perspective on this bill. And yeah, the floor is yours.
Thank you. I'm Josh O'Hara. I'm the supervising attorney in the Burlington Public Defender's Office. Here to testify on behalf of the Defender General about S87. We do not necessarily oppose or support S87 as it's drafted. Yesterday, the committee heard a lot of testimony about the procedure that's outlined in these statutes. I thought I'd go over it just briefly again. When a person is wanted in another state or found here in Vermont, they can be arrested either with or without warrant, and then a person is brought before a judge under Section 4955, which Section 1 amends. At that hearing, a judge is required to, under Section 4956, impose bail, and then set a date about 30 days from the time the person crosses the border for the person to essentially turn themselves in on the governor's warrant if one is reduced at that point. Thereafter, if we get to that 30-day mark and the governor's warrant has not been secured, under Section 4957, which the bill does not amend, the prosecution can ask for an additional 60 days to try and secure the governor's warrant. And a judge at that point can either continue the bail or whatever conditions have required this person to say and come to court, or the court can discharge the person at that point. The effects that Section 1 would have would be to take that 30-day period and make it 120 days without then amending 4957. And so what the Supreme Court has described as an initial 90-day period for the prosecution to get a governor's warrant, under this bill becomes 180 days time when they can get the warrant. And because there is bail, because bail is required to be imposed under 4956, this creates for our clients the potential that they'll be held essentially double the amount of time that they would have been held otherwise. So we don't necessarily support S87 as drafted, because this would mean that our clients are exposed to additional incarceration for a longer period of time. But I also recognize that the extradition clause does not lay out a procedure, and the Vermont Supreme Court has explained that it's called state versus all, that the deadlines here really are kind of the legislature's determination of what is a reasonable period. Number one, for the prosecution to get the paperwork that it needs to get in order to fulfill the extradition clause requirements, but also it's kind of a balance of what a reasonable time is hold the person while the prosecution tries to get that warrant. So while can't really support it because of the extension of the amount of time that this would entail, this never propose it either. This really is a decision that the legislature has to think about what's reasonable under the circumstances. My experience is that when we hit that initial 30-day period, prosecution will very often request the additional extension. So in practice, if a person is not waiting, this is a 90-day process, and the Supreme Court has held that that's kind of the most amount of time that you can hold a person pending the issuance of the governor's warrant.
What was the name of that case again?
State versus, I just brought a copy if you want to.
Great. Yeah.
Okay. State versus the ball, HEAL.
Thank you.
And there's some language in there about towards the end about what the even drafted that you see more acts we're trying to accomplish, which is really making sure that the contending state, because there's a 90-day limit, make sure that they do what they're supposed to be doing in order to allow Vermont to fulfill the obligation under the Constitution. So that's that's section 1. Section 2 of the bill creates an advanced waiver procedure where if the prosecution can demonstrate certain conditions, the person, it seems to be not entitled to the procedures that are in the 4950 area. I took a look at cases from other states. Those type of waivers are usually upheld as being consistent with the Uniform Act on the grounds that the Uniform Act, and I know we heard testimony yesterday from the Attorney General's office that the sole way to waive extradition is to appear in court and sign the written waiver from the judge. Other states have held that on page 3, lines 10 through 12, you'll see some language in 4967. It talks about, nor shall this waiver procedure be deemed to be an exclusive procedure or limit the powers, rights, or duties of officers of the demanding state or the state. Courts in, I think it's Texas, Pennsylvania, New Jersey have held that advanced waivers are consistent with this because the procedure of that's outlined in subpart A of the statute are not the exclusive procedure. So this, what section 2 tends to do, I think, is just elaborate on what others in the Vermont case would probably as pre-existing authority to this alternative procedure in order to have a waiver of extradition. So knowing what other states have held, don't really oppose that section.
So just to make sure I understand it, what you're saying is that what is being proposed in section 2 of this bill is generally in line with extradition procedure. Is that what I'm getting? Or
right? Other states that have construed this last part of 4967 have held that the procedure in A is non-exclusive, so a person doesn't necessarily need to appear in full in front of the judge, sign the waiver as described in A, and then advanced waivers are probably consistent with this last part.
Yeah.
And so the amendment to add C is probably an elaboration on existing authority to have these kind of waivers. That makes sense. Becky, do you have thoughts on section 3, or did you have further testimony? I didn't have any further testimony.
Okay.
On section 3.
I'm wondering if to stay in line with the Supreme Court decision, would it make sense to have, going back to section 1 instead of 120 days, having it be 90 days, then amending 4957 regarding the extension, having that be, if good cause is shown, then under extraordinary circumstances, and it's a further extension to be granted. Because if we're not going beyond 90 days, and the Supreme Court has said that 90 days is a reasonable time.
Perhaps that's a lot unclear. What the Supreme Court has said in that case is that the drafters of the Uniform Acts kind of came to the conclusion that 90 days is a reasonable amount of time. Way back in 1937, and whenever this bill was, whenever this was enacted. So it's not, no, it's Supreme Court recognizing what the intent of the drafters was.
Yeah, that was my, actually, that was my question, because I looked at that case before, and I was just wondering on your interpretation, because my recollection was it was like they were in Maine, right? And had a 90
Yeah,
day.
so Mr. Hall got arrested in Maine on a warrant out of Rhode Island. He spent 54 days in jail in Maine.
Maine.
Then he got arrested here in Vermont, and he spent an additional 36 plus. And what the Supreme Court held is that the combination of the two periods could count towards the 90-day limit that exists currently in statute.
Right, but it didn't,
And that-
I have the same question as you, is that like, it doesn't mean necessarily that decision that 120 days
Is not.
would be wrong.
Right, right.
It was more an interpretation of the
Of the
90 days.
existing statute.
Right, okay.
I get
Right, I just wanted to clarify that because that was my understanding, but I kind of picked up on the same thing that you did, and I meant to actually ask the AG's office yesterday about that, if they had any concerns. Thank you.
But whatever the number that, the legislature comes up with is the maximum amount of time that a person can be held on bail or without bail under certain circumstances without a governor's warrant fee or numbers. So if you hit 100, under the amendment, if you had 181, the person has to be.
Right, so they could do 121 or 90 or whatever it is.
Right.
Sorry, oh, excuse me.
I just want to make sure that conversation's sort of done because I'm changing the subject.
I did have one more.
Okay.
One more possibility of, perhaps it's for such a time not exceeding 90 days. Then 4957 will allow for a 30-day extension. I feel like 3 months would be sufficient to include one of these cases. Yeah. Anyway, that was just a thought that perhaps we could incorporate. Yeah, with
I can certainly support that. I think 3 months is a long time. My question is around the voluntary waivers and how often people sign those, and sort of the circumstances around that. And sort of what I'm getting at is sometimes we use the word voluntary, but is it really voluntary? You know, what are the circumstances in which we're saying, oh, sign this waiver, it's voluntary, but if you don't. So can you understand that a little bit?
Are you asking from, if I'm advising a client who's been picked up or if you're asking if there's an advance waiver from another state?
I'm asking you about your experience. I don't expect you to speak for other states.
Right. I have to advise the person about the requirement that the judge can impose bail, and that could hold you, right? And if you are to waive extradition, that may speed up the amount of time or might cut down the amount of time you're going to spend in jail, because they will get the others. You will go back to the state that is looking for you, and then you have a conversation about who you are and what your interests here. Some people have. You have Vermonters who commit crimes in other states. They want to spend as much time as they can here around family and things before they go back. So when you get to voluntariness, you have to really advise them about what they're facing, and then have a conversation with them about what their particular interests are, and then they come to a conclusion about whether it's a wages moral procedure that's into statutes. They are, it is balancing the possibility of jail time with essentially less jail time than wherever they go on sometimes.
Okay. And do you have any sense of what percentage of people opt to sign the waiver versus not?
I just guess so.
Okay. And now it's a bit of a speculative question, but it's building on a question and concern I had the other day. Could you imagine a circumstance where someone would charge in a crime or a crime in another state, not a crime in Vermont, that they would Vermont hold them in jail because they've been charged with that crime in another state, or what?
Yes. The point of the extradition clause is that Vermont's going to respect the decision of another state to make a particular thing a crime. Imagine just more every day than where maybe the amount of a narcotic that somebody's possessing might be a misdemeanor amount here, that's a felony amount in another state. That would be not necessarily a extraditable crime here, but it's in whatever state they're going back to. But yeah, Vermont would the judge would be obligated to impose bail on that person and potentially hold that person once a governor's warrant is secured.
Okay.
And is that because of the 14th Amendment?
These are for
Looking at comedy and Committee, any additional questions or comments? Sorry for.
I think I missed the initial introduction of this. I'm just wondering, what was the basic reason for moving in section 1 to 120 days? Was there a?
So I think you came in at the point where we were hearing about an extension that is allowable under 4957, which isn't being amended here. Which provides 60 days. And so typically, from my understanding, oftentimes the state will ask for an extension once they hit that 30 days, turning it into 90 days. And so they're asking for this bill is asking for the default to be 120 days, but that extension still exists. So if the 120 days is hit, they could ask for the 60-day extension, turning it into 180 days.
I guess I'm wondering, what was the rationale for the extension? So under current law, it was 30 days and then an additional 60. What was the rationale for going to 100?
From what I understood in the testimony yesterday, it's basically that 30 days is too short, and it's that they just need more time. And doing that would be a little piece that kind of reduces the workload and the backlog, because instead of oftentimes asking for the extension, it's just default that they have more time to begin with. So in theory, they would be asking for less extensions because they already have enough time. That's what I get.
Okay.
Is that more or less correct?
That's,
With 4957.
yes.
Senator Wilson.
So I understand and respect that if they're regularly asking to increase to 90 days, then decreasing that sort of administrative burden makes sense. But going from 30 days to 120 days seems like a pretty big leap. Going from the potential of, max 90 days to max 180 days, that's such a massive increase. I think I want to advocate for what you suggested about sort of decreasing. If 90 right now is sort of what they have to work with, giving them that as the baseline feels much more reasonable than a potential 6-time increase in the time they have.
And then taking away the 60-day extension possibility.
I think perhaps it's reasonable to allow for 90 days as the default. And then if necessary, they can ask for 30 days, which would take them to that 120 days that's being asked for in the first place. That's 4 months of a person being incarcerated while the state is working on the paperwork to potentially get them expedited, which I feel like that's a sufficient amount of time. In my opinion.
Agreed.
I don't know how long it typically takes to do it, but
Well, right now they have a maximum of 90 days to do it, yes, if they ask for the extension.
Yes.
And so we're giving them that as a default with an extension of a potential 30 days. Like right now, they have to get it done in 90 days.
And we're probably cutting out a lot of the requests for extension.
Right.
So that's simplifying.
I can go along with the 90 days with the 30 days of extension. I think it's with a reasonable amount of time.
Michelle, could we
Yep.
get that in a markup? And so that would amend 4957 to from 60 to 30, and then change line 19 to 90 days.
Yep, and then if you want me to also include the AG's recommendation about act corrections where we have law enforcement to place it.
Oh, yeah, yes, please. Well, thank you. That was enlightening and helpful. Anything further or witness? Thank you for your time and thanks for your patience.
Or thanks for accommodating the schedule. Yes, sir.
Thank you.
Oh, she's fine.
where's 4957? I don't see it.
It's not in there.
One of those.
Pardon?
It's not being.
It's not being amended in there.
So it's not.
You want me to send you the site?
So
link?
I don't know where we are. If you're gonna stop, if you're just moving on to something else, I just wanted to briefly report on testimony and
Oh, yeah.
this morning.
Yeah, we'll switch gears to S45. And Kayla, have we heard from Mike if he can come in? No, okay. Yeah, how did that's 45?
So I went into Senate Aggie's board, presented our bill. It was very friendly, I might add. There was a lot of questions, and long story short, it didn't take a straw vote, it didn't questions. They support to get the bill, because the bill in itself offers protections for both parties, and like as far as nuisance suits and so on and so forth. So they were happy before we presented, and I advised them that we hadn't voted on the bill yet. We're expecting the election council to come in. I don't anticipate any changes on the final draft. Is the draft we're voting on?
There were some changes I recommended yesterday regarding mediation and making the language a bit more clear as to what is an attempt and when has an attempt been fulfilled. But aside from that, I didn't suggest that we didn't suggest any additional changes. So
They're on board.
So I have pretty significant concerns with trespass being in the bill. And I asked legislative council how many other states do that. There are 2 states that fully include trespass in their right to farm bills, and 1 state that includes some small aspects of of trespass in their definition of nuisance, for a total of 3 states that include any type of physical incursion onto another property. And I think that crosses a line. It's not a nuisance anymore. It's a physical incursion. Also, one of the states that includes trespass is Oregon, and the only way you can be liable as a farmer in Oregon, if you recall, is to kill someone. And so I have really significant concerns with trespass being in the bill.
So you don't want trespass?
I do not want trespass in the bill.
And in your mind, how would that strengthen or weaken the bill?
Well, I mean, I think it does in some sense weaken the bill in that it no longer protects for a physical incursion from the farm into someone else's property.
This was something I was also going back and forth on. My thought on this is the fact that in order to be liable for the trespass, and I think we all know at this point, the farmer has to be doing something that is outside of the scope of acceptable practices and is a violation of the rules created by the Agency of Agriculture, which with those elements in mind, I think protects the plaintiff or the injured person from a situation in which a farmer is just acting egregiously and just saying, that they're just going to randomly decide to dump manure on the other person's lawn just because they don't like them. That's not a good practice. But, the situation in which the farmer is following good practices, but they get defective equipment from a fence manufacturer and a bull gets out, that's unfortunate and it's a mistake, but it's not that farmer failing to follow best practices or violating the rules. And so I think there is a balance struck there with how we've specified when the liability, when the immunity from liability applies versus when it doesn't. So that's my stand on that.
I would have to expect, though, that all of this would be fact specific and case specific. If the court and the jury looked at if that was an accident, I would have to imagine that those facts would be taken into account.
Yes, but that's where we get into where does the burden lie, and does the plaintiff should it be the defendant, the farmer, taking the time to pay tens of thousands of dollars to gather expert witnesses to say I wasn't breaking the rules, or should it be the plaintiff saying here's the evidence that you were breaking the rules? That's my take on it. I think, also getting your foot in the door is a lot easier than, when you actually get into discovery and, motions practice and the actual trial. But yeah.
Yeah, I have significant concern when it comes to beyond nuisance and actually physical incursions into someone else's property. And I just don't feel like the three other states that have some version of that. One of which being the only way you're liable to kill someone, that doesn't feel like where I want to be moving. I also have significant concerns about, and I recognize this is the I committee, and I hope the I committee will consider this, but I think in 2025, the definition of what is a farm are too lenient to be. And as you know, I have a constituent. There's a whole issue that I'm having with this, and I just think that framework of $2,000 of agricultural product sold in a point in time where a dozen eggs cost $10 it's too low. And so I don't feel like this bill strikes the balance of making sure that everybody is protected adequately.
Well, coming from Franklin County, okay, I'm not dealing with 200 ducks and 3 goats on somebody's property here. I'm dealing with a large infrastructure of farming community to the Franklin County. And as election council testifies, there's really no standard right now for what's considered general farming practices. So I think that by leaving both the nuisance and trespassing in there, we're going to find it's not going to stop litigation. This is going to finally give us a standard what is generally considered farming practices in the state of Montana. If we take it out, I don't know where it leaves us, but the bill doesn't lean one way or the other. The bill still allows people to file a suit. It still protects our agricultural community from unnecessary spending of thousands of dollars. Whereas this is the only law I'm aware of that the burden is placed upon the individual who's accused. By, as you well know, in the state of Vermont, that's not the way that it is. The big criminal courts, whatever else. It is based on the preponderance of evidence, so that 15%. I don't have a problem leaving nuisance and trespass in our.
Bill, real quick. Take your time.
Well, I guess what I would say is initially I did have similar concerns about trespass. I take the point about, it would have to be outside the scope of generally accepted practice. And from my time on the Ag Committee, I feel like that's clear enough for a court to decide. So I'm okay with what we've worked out with the Ag Committee. But I wouldn't be surprised if the other body doesn't focus in on that piece.
Yeah. Thank you.
Yeah, I kind of fall in that same area where, right now currently it's on the farm and prove that you're doing it correctly and everything like that. The amount of money that you spend on litigation, all while trying to run a farm, which a lot of farms sundown into the night.
Yeah,
they're working, 24 hours a day sometimes. So I think this bill kind of brings it back around to a traditional sense of litigation where, the person that's affected in this case, whether it's trespass or nuisance, has to prove as to why, and with generally accepted farming practices. I think the bill strikes a good balance there.
so good.
And I hear your concerns about those limits of, $2,000 and things like that. Be curious. Like current use, we have limits there for income and how much has to come from the land and things like that. So definitely hear that concern.
I think that until we hear from Michael Brady, I think he's a Senate Natural Resources dealing with salt. Probably. So until we hear from him, the new version with whatever ideas he came up with regarding mediation, can't vote on it yet. I'd like to vote on it today. We've got time. So we will take a break from now.
Did we do the resolution?
No, we don't. And once we hear from Mike, we'll come back. Well, come back around, actually, hold on. Bill, can you also just note on the agenda that we talked about S45, just because I know there's a lot of people following this and they look at the agenda, they might want to watch the video.
Yeah.
Please and thank you.
And Michelle said that she'll be back up to the 15.
Okay, perfect. All right. So let's take a break until 10:15. And if Mike is available before that, I'll just text everybody, we'll come back to review